welcome to the Orange County Courthouse. We're excited to have you here this year for what will be a special Inside the Courts. For the first time since its inception in 1999, Inside the Courts will follow a single criminal case from start to finish over all 3 nights. The case begins with a simple traffic stop, something that most of us have probably been involved in over the years, that ends up being not so simple. Judge Karsten, who is here with us, will walk you through that stop and explain the legal basis for search and seizure, with the stop eventually leading to an arrest. Next week, you'll hear from Judge Adams, who will cover the defendant's initial appearance and all the legal procedures that occur before the actual trial. And finally, in week 3, you'll hear from Judge Tanya Wilson, who's here with us today, who will walk you through jury selection and trial. While this deep dive into the anatomy of a criminal case represents a special educational focus for Inside the Courts, it's not the only reason why this year is special. After 18 years on the bench and 9 years hosting Inside the Courts, my dear friend Judge Robert Egan will retire at the end of April. And you can tell I'm getting a little sad already. His nearly 2 decades of fairness, wisdom, and dedication to justice have shaped not only the courtroom, but our community as well. Judge Egan brings the same calm judgment, steady leadership, and deep sense of responsibility he's known for on the bench to Inside the Courts, guiding us, challenging us to think critically, and reminding us why education and justice go hand in hand. While he will be greatly missed, Judge Egan is leaving Inside the Courts in the more than capable hands of Judge Eric Dubois, who is also here with us today. You can expect the same dedication and guidance under his leadership. So, without further ado, let's give a warm round of applause to thank Judge Egan for his dedication.
Thank you, Judge Manion, and good evening, everybody. I did not expect those kind words, but it's such a treat for us to have Chief Judge Manion here today to welcome everybody. She's such an asset to the Ninth Circuit and has been a fantastic leader, and we are blessed to have her. Okay? This has been one of my favorite projects in the past 18 years, and I sincerely thank each and every one of you for coming out. I recognize so many faces, and those of you who've been here longer than I have will remember this actually started with Judge Mike Miller, who started Inside the Courts now, I believe, over 20 years ago. So all I did was step into what Judge Miller had already, I think, created with Julio's help and the rest of the court management. So this is, and Judge Munion's absolutely correct, this is a little bit different type program because we're dealing with the same fact pattern for 3 weeks. What actually happens when a traffic stop, a routine traffic stop, turns into an arrest, okay? We're going to find out over the next 3 weeks. We're going to answer that question by following a single scenario from start to finish. Our first presenter is Judge Keith Karsten. Judge Karsten brings a deep background in criminal law. He currently serves as the administrative judge in our circuit criminal division. Much like Judge Munion's job as a chief judge, it's a thankless task. It carries no extra pay, and it's a lot of work. And Judge Karsten is currently in charge of our criminal divisions here today. He is board certified in criminal trial practice. He previously served as an assistant state attorney here in the Ninth Circuit, and he was also a criminal defense lawyer before he was appointed judge in 2013, I believe. Was that right, 2013? Judge Karsten seems to have a knack for getting assigned a bunch of high-profile cases. A few years ago, I remember every time I turned on the TV, I'd see Judge Karsten, I'm like thinking he's turning into Judge Judy or something. But he understands this stuff and has handled some of the toughest cases. He's created a realistic traffic stop scenario, as Judge Munyon mentioned, and you can actually see this encounter firsthand. Okay, so without further ado, please help me welcome Judge Keith Karsten.
Well, thank you, Chief Judge Munyon. Thank you, Judge Egan. Thank you, Judge Dubois. Thank you, Judge Wilson, for being present. I put together a PowerPoint, and I have to confess, this is one of the first PowerPoints that I've done. I'm excited to see if this works. We've run through it a couple times. So, Judge Egan is correct. I had the idea of bringing you along on the traffic stop so you'd have a better understanding as to how these things typically initiate. Before we get started, though, I wanted to just hit a button. I want to thank some of the folks that have tirelessly worked to bring this presentation to you. I'd like to thank Julio Semino, our Director of Court Services. We have Franny Ferrara, we have Cameron Gordon, Maylene Vega, Reagan Matthews, Lisa Francis, April Boyd. We have Sergeant Murphy, who and Deputy Jenkins present with us. These programs cannot go on without their professional services, and we're very lucky to have them here at the Ninth Judicial Circuit. So there I am. That's my judicial glamour shot. A smiling and seemingly much more rested, Honorable Keith A. Karsten, a title that makes my friends from high school still shake their heads with confounded amusement. Judge Egan was correct. I was born and raised right here in Orlando. I went to Dr. Phillips High School. Was good buddy with the talented Wayne Brady, who was in my graduating class. 13, when I had the honor of being appointed by then Governor Scott. I have been a prosecutor and a defense attorney, so I do have a unique perspective of doing the criminal process from every perspective, with the exception of a defendant. And if I was, I wouldn't tell you. Unfortunately, I look forward to my retirement days like Judge Egan, and I look forward to serving on a jury at some point, because we as judges, prosecutors, and defense attorneys don't often get that opportunity. So I'm very curious as to the discussions that goes on in the jury room. As you can see from the photograph and from me, this assignment does take a toll on your hairline. So I hope you recognize the sacrifice that we make. But every day I wake up thankful for the opportunity to be one of your circuit judges in the same circuit, in the same town that I was born and raised in, now raising my family. So thank you for that opportunity. Here's what I'm hoping to take away. We're going to see the stop at the end of this presentation. I'm hopeful that you will be comfortable identifying and analyzing the following concepts. Number one, was the stop lawful? Number two, was the subsequent search lawful? Number three, the differences between the concepts of probable cause, consent, and search incident to arrest that will justify a search. The Miranda warnings, the timing, and one's right to remain silent. The very quickly changing laws on firearm possession. Is a defendant or is someone who is stopped prohibited from carrying a firearm? Charging discretion. What happens after the officer has made a arrest decision, and what is involved in that decision-making tree? And any potential sentencing enhancements based on the facts that are presented to a law enforcement officer as they interact with a member of the public. So I'm hopeful this works with the magic of iPhone iMovie. we're going to watch a overview of the scenario, the case of the ordinary traffic stop that wasn't.
Turn it off for me. And place the keys on the ground. Stay right there. So look like it. Is there anything you can tell me about? Grenades, rocket launchers, RPGs. Nothing I can do right now.
Okay, so stop doesn't look all that complicated. Looks like something that we might see on an episode of Cops or something along those lines. So let's meet our two participants now. Remember, these are the only two participants that are going to be present at this initial stop. On the left, we have the unshaven Danny defendant. And on the right, we have the equally unshaven Officer John E. Law from the fictional town of Windermere. So our Windermere officer is enjoying the changing policy where he can grow some facial hair. And I'm going to give you a little bit of background as to our two participants that, again, are the only two participants in this citizen and governmental agent encounter. So on your left, we have Danny Defendant. He's 25 years old. He works as a waiter in a popular chain restaurant. He was doing great in college until 2 days before his 20th birthday, or 2 days after his 20th birthday. In Georgia, he and his college roommates went out and they went to the rival school. And when they got to the rival school, they found a 8-foot statue of the rival mascot. And in the spirit of fun, they were going to climb the mascot and deface the mascot's name. Danny Defendant climbed up the mascot. Apparently, the School of Construction at this school was not very adept, and they had not properly secured. Sorry. Do you need me to speak through this? Yeah. So they had not properly. Is that any better? Okay. They had not properly secured the statue. The statue toppled over and suffered more than $1,000 worth of damages. Well, Danny Defendant was dazed. The dorms emptied, and he was caught red-handed defacing the mascot. He went to court as a first-time offender. Unfortunately for him, the judge was a graduate of the rival school and adjudicated him guilty of a felony for his first offense, which is a discretionary decision that a judge would have. Danny Defendant successfully completed his probation. He was about 4 years behind him in the past, and now he is looking forward to sealing that record when he is eligible. On the right is our officer, Officer John E. Law. John is 29 years old. He is a 5-year officer with the Windermere Police Department. He was previously a deputy sheriff with the Citrus County Sheriff's Office. He had 4 years of experience there until he fell in love with the local waitress at the diner in Windermere and moved to Windermere to start his life there. He is a field training officer, which means that he has specialized training and that he trains new officers, and he makes a determination as to when they are prepared to work alone. So breaking this stop into its component parts, we're going to start, with the initial traffic stop.
271-1050. The second and fours, 42869 Golf, Delta Hotel Hotel, 69G DHH, via silver Nissan SUV.
1908.
Okay, so did anybody pick out anything that they observed that seemed out of the ordinary or slightly out of the ordinary? Just by a raised hand? Yes, ma'am. Broken tail light. Okay. Anyone else? Anything different? Okay, California rolled right through that stop sign. Yeah. Anybody else recognize anything that may be amiss in the driving pattern or the rules of the road? Signal. Took a right turn, no signal. Traffic is potentially affected. The law enforcement officer's car is behind him. What's the deal with the tape? Let's watch it again. All right, so got some tape over that right tail lamp, maybe an equipment violation. I'm not sure if that was broken. How did the officer initiate the traffic stop? Lights and sirens, right? Would a reasonable person believe that they were being stopped by law enforcement based on a police car being behind them and putting on their lights and sirens? Yes, okay. I would agree with you. So now the intrusion into this citizen's life, Danny defendant, has now officially begun. He has a reasonable belief that he is being stopped by law enforcement who is operating in their official capacity. So what has to legally happen before that can be a lawful stop? Well, the answer is called probable cause. Probable cause for a traffic stop exists when an officer has a reasonable belief based on objective facts that a driver has committed a traffic violation or that a crime has or is being committed. This suspicion must be articulable, not mere hunches to justify the Fourth Amendment seizure. So this is an allegation of a violation of the Fourth Amendment seizure, or is likely to be in the future. It does qualify as a Fourth Amendment seizure because one of our citizens' movements has now been curtailed, and he has a reasonable understanding that his movement has been curtailed, and he has been seized. This is a seizure of the person. So what could justify the officer making a determination that based on objective facts, the driver has committed a traffic violation? Well, the first is one that we talked about. It's a little bit combined. Tail lamps. Every motor vehicle, trailer, semi-trailer, and pole trailer, or any vehicle which is being drawn at the end of a combination of vehicles shall be equipped with at least 2 tail lamps mounted on the rear, which, when lighted, shall emit that red light from a distance of 1,000 feet to the rear, except for very old cars when they were equipped with only 1 tail lamp. If they are equipped with more than 1 tail lamp, the lamps shall be mounted on the same level and as widely spaced laterally as practical. So let's watch that video one more time and take a look at those tail lamps. You can see them right there. How many tail lamps do we see? 2, right? So this is a newer vehicle with that third tail lamp. And so, does he have enough tail lamps to lawfully drive on the roads of the state of Florida? What do you think? Anybody say yes? Has enough. All right. Anybody say no? Does not have enough. Okay. All right. So let's look at what the courts have decided as to this specific issue. The Florida 2nd District Court of Appeals definitively held that a traffic stop was not authorized when one of 3 brake lights was inoperable. The court explained that if 2 of the vehicle's brake lights were operational, this is sufficient to comply with the requirements of Section 316.222, what we just read. The court specifically noted, well, let's go back. Before we get there, there's a picture of the car. Clearly has 2 brake lights illuminated. So the 2nd District Court of Appeals would say not probable cause to initiate a traffic stop. Now, wait a minute. We remember that from our 316.221, it says that on vehicles equipped with more than 1 tail lamp, the lamps shall be mounted on the same level and widely spaced laterally as practicable. Does that change anybody's mind? Now, is it an unlawful stop that what people who thought might be lawful? Well, interestingly, 2nd District Court of Appeals says, who cares? The statute does not require that the operable lights be parallel to one another, but only that they be located in the rear of the vehicle. It's an interesting ruling. I have not read the facts of this case, so I'm a little bit unclear as to why they felt that the statute did not specifically lay out that they had to be parallel. But that is what they have decided, and so were this challenge for that reason and that reason alone, the failure to have operational brake lights might be a reasonable challenge, and that's something that Judge Adams is going to be discussing next week. So, is there any other reason that would make this constitutionally permitted a constitutional stop pursuant to probable cause? Well, the law says that we follow the objective basis test for stops under the 4th Amendment, where an officer must have an objectively reasonable basis for the stop. Mistakes of law, if objectively reasonable, can justify suspicion to conduct a stop, but incorrect interpretations unsupported by statutory or case law precedents may invalidate the stop. Could Officer Johnny Law have a copy of the statute book and say, well, those clearly are not parallel, so I'm going to initiate a traffic stop? Would that be a reasonable mistake of the law? That would certainly be litigated and something that could be considered in the pretrial litigation, which you will learn about next week. So I throw that out there just as a little tidbit, as food for thought to be thinking about perhaps for the discussions next week. What about some of the other things that we discussed? What about that turn signal that is required? When is a turn signal required? No person may turn a vehicle from a direct course or move right or left upon a highway unless and until such movement can be made with reasonable safety, and then only after giving an appropriate signal in the manner hereafter provided in the event that any other vehicle may be affected by the movement. Well, Officer Johnny Law's vehicle was pretty close to the car when they made that right-hand turn, and there was no indication that he was going to make that turn. It was indicating he was coming sort of to a stop at the stop sign, but he initiated a right turn without any turn signal. Perhaps the turn signal doesn't work, perhaps it's damaged, perhaps he wasn't going to use it anyway. Could this be a reasonable argument for probable cause to initiate a traffic stop? Certainly the officer could have been affected, not knowing he was going to stop and turn right. So, was the stop legal? We also observed that California rule. That one's pretty clear. We all know what a stop sign looks like. We know that stop sign looked DOT approved. It wasn't carved out of wood and 2 feet tall like you would see in a parking lot. This is a regulation DOT stop sign. It's big, it's octagonal, and has the word stop on it. So also, it was pretty hard to see in the video, but there are stop bars. They are painted on the ground of paved roads, and the stop requirement is that, and I don't have this one printed out, but you must stop behind the stop bar. The stop bars are designed to be a safe place for you to stop behind so that you don't affect other traffic, and they are checked to make sure that you can visually see around hedges and corners at a four-way stop. So it was pretty clear that he blew both of those. So the ultimate answer would be one for the courts to determine if they were challenged, but it appears that there is sufficient basis, an objective basis, an articulable basis for the law enforcement officer to justify a stop and a seizure of the person of one of our fellow neighbors and citizens. So now at this point, again, the government is committed. They have intruded on the life of Danny, one of our neighbors and citizens, and the officer is now going to have an interaction with Danny, and he's going to do that by getting out of his patrol car and walking up to take a look at Danny and to make some observations. I'm going to try and pause this when he gets up to the window. All right, so now he's at the window. I think I heard it already. What did somebody observe when he walked up to the vehicle? Put his finger on the back, the left. Turn signal, it's plastic. It would be a good surface to capture a fingerprint. In the days before body-worn cameras and cameras in vehicles, law enforcement officers were trained to do this. So if this stop became a dangerous event for Officer Law and he was incapacitated, he's already given a general description of the vehicle. When they put out the bolo or be on the lookout for this vehicle, they would immediately know where to check to make sure or to verify that this is the vehicle in question, because they would start looking for Officer Law's fingerprints on the back taillight. So that's just a little law enforcement tidbit. It's probably not necessary at this point in the age of cameras, but they are trained to do that, and it's another piece of the puzzle should things go horribly wrong for Officer Law. So now he's at the driver's side, and it's not captured in the video, but we're going to make an assumption that Officer Law goes up to Danny and he says, "I need your driver's license and your registration." Does Danny, defendant, have an obligation to hand over his driver's license to a law enforcement officer? Anybody have any thoughts on that? Yes? Do we have our yes crowd and our no crowd? Anybody in the no crowd? All right. We've all seen on the internet, you don't have to give your driver's license to law enforcement officers, correct? No, bad advice. There is a statutory requirement to possess and present your driver's license to a law enforcement officer. Every licensee shall have his or her driver's license. They'll have it with them, and it must be fully legible, with no portion faded, altered, mutilated, defaced, in their immediate possession at all times when operating a motor vehicle, and shall present or submit same upon the demand of a law enforcement officer or an authorized representative of the department. Creates a clear duty to both possess and present. So do not fall for some of the things on the internet that indicate, well, you just have to show it to them, or you can place it against the window and not roll your window down. Please don't do that. That's going to escalate that situation, and it's unnecessary. It is a statutory requirement, and failure to do so can be considered a misdemeanor offense, which is a criminal offense. So at this point, what do you think? Do you think Danny is free to leave? Can he just decide, I'm pretty sure I didn't violate anything, and after he has this initial interaction with the officer, he is free to leave? Well, I think you're all in concert with that thought. He is not free to leave. he is detained, and he must give up that driver's license and present his information to the law enforcement officer. So let's continue on with the video, if I can. We'll watch the beginning part again. He's got the driver's license. He's got the registration. He is plugged into a system called David. David is the driver and vehicle information database. He can access that on his computer. He's going to get information about the driver and the vehicle information, whether it is properly tagged, who it is registered to. He's going to get some biographical information about Danny Defendant. He's going to get his age. He's going to get his driver's license number and compare that on the David system. He's going to get an address to try and make some determinations as to whether Danny is close to home or is he unusually far away. Who that vehicle is registered to. Is this Danny's vehicle? That's all the information that is going to be available to him wirelessly in just a matter of moments through the David system. Now, David is only authorized to be used by approved law enforcement and governmental users. So it is not something that is available to the public, and it is because it has sensitive information such as people's addresses, their social security numbers. On occasion, it has been found out that law enforcement officers or those approved users have looked up an old girlfriend or have tried to find somebody that they would like to, that cut them off in traffic and they would like to settle their hash. That as well is a criminal offense. They may not misuse the David system, so occasionally, unfortunately, you will see on the news that approved users are caught improperly using that system. At the same time, he is waiting for that information to come back on his computer. He's going to call in to dispatch, and he is going to give the driver's license information to dispatch. They are going to do a warrant check. They are going to see if Danny has currently any warrants out for his arrest. They are going to give him information as to whether Danny has been convicted of a felony in the past, because as you see in a few minutes, that is going to be important information for Officer Law to have. And finally, he's doing those tag and registration checks that we would expect him to do. So let's try and let this play out. Decision all of that information. What did he do? Did he give Danny a citation for those egregious violations that we witnessed? No. He exercised his discretion as a Windermere officer and issued a warning. Well, wait a minute. You got probable cause for a stop. You've issued a warning. Does that eliminate the need for anything further? Well, is there still PC for the stop? You didn't issue a traffic citation. It says probable cause for a traffic citation. You didn't do it. The answer is no, doesn't matter. In Florida, a traffic stop must be based on either probable cause of a traffic infraction or reasonable suspicion of criminal activity. The issuance of a ticket is not a prerequisite for the stop to be lawful if probable cause exists. And they have upheld stops where the officer observes a traffic violation such as a equipment defect, like that taillight, improper window tint, maybe expired tags. We didn't find that in this case, establishing probable cause. The officer is entitled to rely on these objective bases when making the stop and need not anticipate or rule out any possible defenses for the driver. So this really is only going to be important if, as in this case, the officer has some reason to continue on with his interaction with one of our fellow neighbors and citizens. He's given his driver's license back. He's given his registration back. He's given the warning back. There's no other police activity that is necessary for the observations that the officers had as to the driving pattern. Is the stop over, and does that matter? Well, Florida courts have consistently held that a traffic stop must last no longer than the time it takes to write the traffic citation. That time has passed. Maldonado v. State, a 2008 case, established this principle in Cresswell. The Supreme Court held the stop must last no longer than the time it takes to write the traffic citation, and to justify detention beyond this period, an officer must have a reasonable suspicion based on articulable facts that criminal activity may, that word's going to be important, may be afoot. The standard requires more than an inchoate and unparticularized suspicion or hunch, but it is something less than probable cause. So initial stop needs probable cause. To detain that, or to retain that stop and to continue that stop needs something less. That something less is reasonable suspicion. So the answer to this question, is the stop over and does that matter? Well, yes. And yes, it does matter. It does matter that the stop is over because the intrusion, the governmental intrusion into one of our fellow neighbors and citizens' lives is over. And does that matter? Yes, they need something more to continue. So what is reasonable suspicion? Reasonable suspicion standard requires officers to possess a particularized and objective basis. That should sound pretty familiar from our probable cause definition. Suspecting criminal activity. The particularity requirement means that an officer's suspicion must be grounded in specific, articulable facts. Again, pretty familiar stuff. While objective requirement means that the court must view the facts and circumstances through the lens of a reasonable police officer, giving due consideration to his or her training and experience. So what do we know about Officer John E. Law? We know that he has been an officer for 9 years. We know that he is a trained officer that signs off on other officers before they're ready to go. He is a training officer and has some particularized experience. So when viewed through the lens of a reasonable police officer, giving him a consideration of that training and experience, we would make a determination as to whether reasonable suspicion exists to continue on with the detention. Well, as I said, this may sound a little bit like the definition of probable cause. That definition was a reasonable, probable cause, a reasonable belief based on objective facts that a driver has committed a traffic infraction or that a crime has or is being committed. Reasonable suspicion is very understandably less than that because it is a suspicion that criminal activity may be afoot. The word suspicion is right in the definition. So the officer does not have to have a articulable fact that something has been committed, only a reasonable suspicion that something may have been committed to continue on with the detention. And that makes sense because the seizure of a person, one of our fellow neighbors and citizens, is an extreme intrusion on somebody's liberty. And we want the basis for that stop to be a higher basis of probable cause. We also want law enforcement to have the ability to search a place that they have a reasonable opportunity to search from a place that they have a lawful and meaningful opportunity to be, to make observations as to whether reasonable suspicion exists of a crime that is being committed. So it makes a lot of sense that the initial stop needs to be probable cause, and then to continue that stop to requires reasonable suspicion. So let's argue that when Officer John E. Law walked up to Danny Defendant's vehicle, notice that the windows were down. In the back seat on the right, we saw this black backpack with something that appears to be firearm related or perhaps looking like a part of a suspected firearm. On the left, probably more readily observable and identifiable, is this small object here by the shifter. And this appears to be a hand-rolled cigarette or some kind of hand-rolled smoking instrument, and that immediately, being unusual in this day and age to hand-roll your own cigarettes, would probably pique the interest of our law enforcement officer, John E. Law. So, is there reasonable suspicion grounded on specific facts that the officer could articulate to someone as to why this traffic stop should be prolonged? Let's take a look at the next interaction that Officer Law has with Danny Defendant.
But for right now, I need you to make sure the car's in park. And go ahead and turn it off and put the keys on the dashboard, please. And step out of the vehicle for me. Go ahead and turn and face the vehicle. Go ahead and turn and face the vehicle. Place your hands on the vehicle, please. Do you have anything in your pockets that are going to poke me, stick me? Nope. What's this right here?
It's my lighter.
Your lighter? Okay. All right. Stay right there. All right, go ahead and put your hands down to your side for me, please. All right. Right now, I'm going to put you in cuffs. You're not under arrest, okay? This is just a detainment for the time being, okay? All right. All right, come to me real quick. All right. I'm going to stop right here. You can turn around. So the reason I pulled you out of the vehicle is because I could smell marijuana in the car, and on the center console what looked like a joint, okay? Is there anything you can tell me about that? Who the car belongs to? Why those things might be in there?
It's my cousin's car. It's not my car. So I don't know why any of that stuff's in there.
Okay, you didn't notice the joint in the center console?
I didn't.
Okay, so things have gone from bad to worse for Danny Defendant. He thought he was going to get off with a warning. When the officer came up and interacted with him the first time, he told him that he smelled the odor of marijuana. It smelled like weed in the car. I've heard secondhand anecdote evidence that burning marijuana has a distinct smell. And I know you guys wouldn't know about it. You're going to have to take my word for it, but burning marijuana has a distinct smell. That was the first thing that he said to Danny Defendant. So, is that in and of itself, the smell of burning marijuana in a vehicle, sufficient to establish reasonable suspicion or even the higher level of probable cause for a search of the vehicle? Does anybody have any thoughts on that? Anyone? The whole car smells like weed. It smells like a Cheech and Chong movie. Nobody thinks that's enough for the officer? Yes, you do think it's enough for the officer. All right. I'm glad that you said that because you unfortunately are wrong. In October of 2025, the Florida District Court of Appeals issued a landmark decision in Williams v. State holding that given the legislature's decision in defining and legalizing discrete forms of cannabis on basis that are manifestly not discernible by smell, such how it was procured, the mere odor of cannabis standing alone can no longer make it clearly or immediately apparent that the substance is contraband without conducting some further search. Florida courts have recognized that while cannabis odor alone may be insufficient, it remains a relevant factor to consider among the totality of the circumstances. In the 5th District at Ford v. State, they emphasize that probable cause must be determined based on the totality of the circumstances. So, Officer John E. Law's very well experienced nose in detecting the plain smell of the odor of burning marijuana is not in and of itself enough to substantiate probable cause for some further search. But as you saw, the Florida courts gave Officer Law a safety valve, and that safety valve is that it remains a relevant factor to consider among the totality of other circumstances. Can anybody think of any other circumstances in that search or in the plain view that the officer could see through the window that would substantiate that maybe this is actual burning cannabis. Anybody think anything? Yes, sir?
Could be that that Danny is under the influence.
Okay, all right. So there could be an argument that him California rolling that stop and not using his stop sign was a indication of impairment. Reasonable argument that would be considered by the court, probably made by a crafty defense attorney. So what other items did the officer find? Well, he found a lighter in his pocket. Pretty unusual to take hemp or those kind of supplements by burning it. The little joint that he found on the center console. Probably some other factors to consider along with the driving pattern that may establish the basis to conduct a probable cause search, and we'll talk about the probable cause search in a minute, based on purely the odor of marijuana. Well, let's talk about some of the other stuff that happened during that interaction. Let's watch it one more time. All right, so based on what he observed, he pulled him out of the car. Anybody think that the stop's been converted into a de facto arrest at this point? Take a look at Danny, take a look at the officer. Does anyone think that, in Danny's mind, I'm arrested. Does anyone think that that could be a consideration? That's reasonable. That's a reasonable thought to have. But the courts have said that that's fine. That does not convert the stop into an arrest. Florida courts have firmly established once a vehicle is lawfully stopped for even a traffic violation, an officer may order the driver to exit the vehicle as a matter of course. Police officer may do that and require that they exit their vehicle. Now, officers need not articulate a particularized basis the driver poses a threat to officer safety to do this. So the fact that he has pulled Danny out of the car and seemingly at this point for some minor violations, had him put his hands on his car, does not convert this into a arrest if there is reasonable suspicion of criminal activity beyond the traffic infraction that we just discussed that would be required. Also, one more time. Whoops. So look at the size difference between these guys. Officer John E. Law is by his lonesome, and Danny Defendant's a pretty big dude. All right. So, is it a good idea, probably for officer safety, that Officer Law put those cuffs on Danny Defendant while he's by himself? I think that's a reasonable conclusion. And that's for officer safety. Now, okay, so Danny's pressed up against the car. Now he's in cuffs, and he's going back to Officer Law's car. Is he now arrested? Anybody think he's now arrested? Is that enough? No. Good answer. All right. So, the use of handcuffs during detention does not automatically convert a temporary detention into a formal arrest. What did he tell him? You're not under arrest. I'm going to put these handcuffs on you and temporarily detain you. Sometimes they say for my safety. It is a significant factor in an objective determination of custody, however. So, the thing that will be decided by the courts and litigated by the attorneys is there an objective basis for Danny defendant to believe he is in custody? Pro, he's in handcuffs and he's being directed where to go and taken from his position from his car into the other car. Con, we've got this case that says use of handcuffs, and the officer says, I'm not arresting you. I am simply detaining you briefly so I can continue my investigation. So I would think that would be a hotly contested issue to be litigated, probably going to be talked about next week, if I had to guess. But the use of handcuffs during detention does not automatically convert that to a arrest, but it is a factor to be considered. All right, let's continue on. Oops. All right, looks like Officer Law has gone into some of the contents of the vehicle. Now he is very dramatically putting them out on the hood of his car. We'll see this all the time on the body-worn camera, so it's easily identifiable as to what items they believe were contraband. And now we have a number of unidentified pills. And I can tell you they're probably unidentified to the law enforcement officer as well. So we'll talk about those pills in a minute. All right, so we know at this point he's had reasonable suspicion to prolong the stop. He has made the observations from those photographs of the handgun, or what appeared to be a handgun, sticking out of that black backpack, and the joint sitting on the center console. Do you believe that we have crossed over to the required level of probable cause again? Because we're back in probable cause land for the search. Does anybody not think there's enough at this point to search? All right, I see no hands. Again, going to be a hotly contested issue next week. Was there enough that the officer knew to establish probable cause? Remember, probable cause is not reasonable suspicion. It is an articulable basis that criminal activity is afoot. So now we're going to get into the officer's qualifications as to those 4 bags of green leafy substance that will be identified by Officer Law. We're going to combine that with the odor of burning marijuana, the lighter, the joint, and the concerning proximity to a firearm in some of those, at this point, unidentified pills. So that will be a hotly contested issue. Did the officer have a warrant to conduct a search? No, he did not. Could he have got a warrant? Perhaps. But warrants are required. Warrants are a sworn document submitted to a judge. On the document, there are a recitation of facts, and the judge makes a determination in advance of a search that probable cause exists from those facts. They are required when conducting a search of a home. Your home is sacred. Your home should be safe from governmental intrusion. Your home needs a warrant to be searched. Always? Not always. There's always a safety valve. The safety valve is exigent circumstances or your consent or that it would be unreasonable to secure a warrant in the time frame that it is necessary to conduct that search. So, oftentimes with the search of homes, we will get the argument that, well, I knew there were drugs in there. We had just done a controlled buy from that residence. They knew we were there because we had knocked and announced, and we heard the toilet flushing immediately, over and over and over again. We have exigent circumstances to go in. We are fearing the destruction of evidence in there. We walked up to the door after a domestic call. One of the residents came out, said everything was fine, closed the door, and then we heard screaming. Inside, screaming, banging, breaking of furniture. Does the officer have exigent circumstances to then re-engage and go in without a warrant? Perhaps. It would be based on the totality of the circumstances known to the officer who would likely be kicking in the door, and they would try and sort that out after the fact if they found any contraband or any evidence of unlawful behavior inside that residence. So, a little couple safety valves for the home, but generally your home needs a warrant. That's why you see on TV, do you have a warrant? They shut the door in the officer's face, and without exigent circumstances, it would be unlawful for them to continue that search. Let's talk about cars. Are cars different? The answer is yes. Cars are different. Why? Cars move. You drive your cars out in public. You're not in the privacy of your home. You're out in the community, observable, and the cars move. So, it is called the automobile exception to the warrant requirement, and it permits law enforcement officers to conduct warrantless searches of vehicles when they have probable cause to believe the vehicle contains contraband or evidence of a crime. It is grounded in the inherent mobility of vehicles and the reduced expectation of privacy individuals have in automobiles compared to their homes. How about exigent circumstances? Could exigent circumstances substantiate a vehicle search without probable cause? Maybe. The case law says that it does not require a separate showing of exigent circumstances, but if Officer Law had peeked in through that open window and seen a large pool of blood or heard moaning from the back of the vehicle, it is very likely that he would have initiated a immediate search based on exigent circumstances, and that would have been something that he could justify but not required for a vehicle. So let's go over some of the other circumstances that substantiate a search. One is probable cause. We've talked about that quite a bit. The second is consent. Did you catch how the officer presented how that search was going to be conducted? Did he ask, may I search your car? He did not. He said, I'm going to search your car. And what did Danny Defendant say? Okay. Is that consent? Consent must be voluntary and unequivocal, and law enforcement officers may request such consent during a lawful traffic stop without requiring reasonable suspicion or probable cause. In this case, again, probably a hotly contested issue. I'm putting on my state attorney hat and said, well, he said he's going to search, and the guy says, okay. So Officer Johnny Law thought he had the green light to conduct that search without any opposition. My defense attorney hat would go on and say, absolutely not. He's acquiescing to police authority. He's standing there in handcuffs in front of a police car with the lights on and being told, I'm going to search your car. And he is making a response that acquiesces to that show of authority, and that therefore is not what kind of consent? Voluntary and unequivocal consent. So again, a hotly contested issue that I suspect will be touched on next week, but food for thought to be in your mind. The next one is interesting. The next one is called search incident to arrest. So, if the officer has made determination that probable cause exists for a formal arrest of Danny at this point, he may conduct a search. The critical requirement is not the sequence of the search and arrest, which means he can search before he formally informs or makes the decision known to Danny Defendant that he's going to arrest him. If it is clear to the court that he is going to be arrested for probable cause, it does not matter that the actual physical arrest occur prior to the search. So that one is often used, and hey, he was being arrested. We were going to arrest him anyway. We need to inventory that vehicle, and we were going to search. And I suspect that will be something that will be discussed. We also noticed, watch it one more time.
So at this time, I'm gonna go ahead and search the vehicle, okay? Is there anything in there that belongs to you that I should be aware of? Got any grenades, rocket launchers, RPGs?
Uses that funny example to try and get the guy talking. Hey, no, I don't have anything like that, but I do have a knife. All right, now he's going in the back. Nope, he's already been in the back. Nope. He's got that joint, putting that out to film it. I think he'll go in the back, grab that backpack. All right. Looking in the back. Grabs the backpack. Mostly closed. Gets the contraband or suspected contraband. Gonna go back and do that dramatic laying out of the items. All right. Is Officer Johnny Law allowed to open closed containers in the vehicle based on what he's observed at this point? What do you think? Who's our no? Anybody say no? Can't open people's closed containers. That he doesn't know what's in there. How could he establish reasonable suspicion or probable cause for a closed container? Anybody think that? No? Can't fool you anymore. Okay. You're correct. When a police officer makes a lawful custodial arrest, remember, doesn't matter the sequence of events. If he's got probable cause to arrest, it's a lawful custodial arrest of a vehicle occupant. Doesn't have to be the driver. The officer may search the entire passenger compartment and examine the contents of any containers found within it. The term container means any object capable of holding another object. It's a pretty good definition. Encompassing closed or open glove compartments, consoles, or other receptacles contained anywhere within the passenger compartment, as well as luggage, boxes, bags, clothing, and the like. However, this holding does not encompass the trunk. Okay, so in our age of everybody driving an SUV, where is the trunk? That is a hotly contested issue as to whether that back little area where all of your stuff goes that you forget about is part of the passenger compartment of the vehicle. But in this case, looked like all the contraband was found in the passenger compartment, and therein it was within reaching distance of the car, it was within the wingspan of the driver, at least in this set of circumstances. Now, interestingly enough, if at the time that he pulled him out of the car, those items were within the reach of him, even outside of his car, then it would be justified to search those containers within. If Danny Defendant was sitting in the back of Officer Law's vehicle, then he couldn't justify the search of the vehicle based solely on the driver being within wingspan. But he's observed it. He's observed the driver within wingspan of the vehicle. Sometimes that last example happens when somebody bails out of a car and they're apprehended later, and they bring them to the car, and then they find contraband in the car. You know, it's hard to establish that that was within the wingspan of the defendant at the time that they observed those items. In this case, less of a contested issue. Let's talk Miranda warnings. What are Miranda warnings? They are your Fifth Amendment United States Constitution rights. They are ingrained in stone. You have a right not to become a witness. It is also adopted by Article 1, Section 9 of the Florida Constitution, which adopts that no person shall be compelled in any criminal proceeding to be a witness against one's self. The Miranda warnings are a required warning of those rights. They are required to read that. Many of the officers will pull out a little card out of their pocket because it is very important that the language that they use is specific. So let's watch Officer Law give Danny Defendant his Miranda warnings.
Okay, so I'm gonna go ahead and read you something right now called your Miranda warnings, okay? Doesn't mean you're under arrest still. I'm just gonna do it before I ask any questions, okay?
Okay.
All right, so you have the right to remain silent. Do you understand that? Mm-hmm. Okay. Anything you say can and will be used against you in a court of law. Do you understand that?
I do.
All right, you have the right to talk to a lawyer and have him or her present with you while you are being questioned. Do you understand that?
Yes.
All right. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. Do you understand that?
Yeah.
All right. You can decide at any time to exercise these rights and not answer any of the questions or make any statements. Do you understand that? All right. Knowing your rights, you wish to speak with me.
I guess.
Okay. I have some questions about some things I found in the vehicle. Okay. All right.
Alright.
So when I came up to the vehicle, I smelled marijuana, and I also noticed with what I appeared to be a joint next to your right leg on the center dash.
None of that's mine.
Okay. All right. The vehicle belongs to who?
It belongs to my cousin,
Who's your cousin?
Justin.
Justin. Justin have a last name?
Well, it's like my mom's
Okay.
cousin.
That's fine. How long have you been driving the vehicle?
About a day or two now.
All right. There was also a backpack in the vehicle, in the back seat. Do you know anything about that?
No, I don't know anything about
So
it.
you wouldn't know anything about what's inside the vehicle?
No.
Okay, so you've never seen any of the marijuana or the pills that are in the backpack?
No, none of that's mine.
What about the firearm? You know anything about that?
No.
Okay, so Officer Law, during the detention period, has decided to ask Danny some questions, and the Fifth Amendment right has been invoked. When is the Fifth Amendment right to remain silent invoked? Number one, when you are in custody, and number two, when you are being interrogated. That is the only time that the Fifth Amendment right is invoked. If the law enforcement officer was asking him questions at their initial stop and he was answering questions, there would likely be an argument that he was not in custody. But let's take a look at Danny right now. Danny's behind those bars in the patrol car with handcuffs on. Do you believe, not arrested, but do you believe Danny is in custody? Yes, Danny is in custody. Is the officer asking him questions or interrogating him, which is defined as asking questions designed to elicit an incriminating response? Maybe. Probably. And this, again, will be a hotly contested issue. Are these background questions? Are these questions about identity of Danny or the owner of the vehicle for an inventory search, or if the vehicle is going to be towed? Maybe these would be questions that would be answered in post-arrest litigation as to whether these questions were designed to elicit an incriminating response. But judges will often, and I would err on the side of caution and probably find this to be custodial interrogation. What did Danny say that was damaging to his case? Who knows? It wasn't mine. It's not my car. It's my cousin's car. I didn't know any of that stuff was in there. Is any of that statements appropriate for the exclusionary rule, which would be what would be challenged? That is how you would eliminate evidence or statements from a defendant. Again, a discussion for post-arrest litigation that, okay, is the exclusionary rule, or is the officer acting in a way that is so unlawful that as a deterrent to that unlawful behavior, we are now going to exclude admissible evidence that would otherwise be admissible. So there's always a safety valve for the judge to make a determination. Yeah, the officer was not correct. The sequence wasn't right. He made some statements that could be incriminating, but is it appropriate to exercise the exclusionary rule? And I can tell you that the Florida Supreme Court and the Supreme Court is loosening up on that. They used to be very strict, and now they're like, let's give the judges a little bit of discretion when that very strict tool should be imposed and exclude what would otherwise be admissible evidence. He asked, can I ask you some questions? And what did Danny say? I think he said, I guess. Okay. Again, is that a knowing and voluntary waiver of his Fifth Amendment right to remain silent? Probably not, but a crafty state attorney could make that argument, and it might be persuasive based on the totality of the circumstances. The officer would get up there and testify and say, you know, here, we had a cordial conversation, and he didn't indicate any reason why he wasn't giving that statement to me voluntarily. So another will be another consideration that will be hotly contested. And finally, let's see what Officer Law did here with Danny, defendant.
All right, so for right now, sir, based off of everything I observed and everything in the vehicle, all right, I'm going to go ahead and place you under arrest for being in possession of narcotics, okay? All right, so just sit tight with me while I get the rest of all the rest of the paperwork done, okay?
All right, so Officer Law has gone from probable cause for the stop to what he would argue would be reasonable suspicion for a detainment that went beyond the time that it took for the traffic stop, back to probable cause for the search, and now probable cause for an arrest. And the definition doesn't change for probable cause. It's that articulable set of facts that criminal activity is occurring. So now let's talk about some of the contraband that we saw dramatically put out on the hood of the patrol car. We have over here what appears to be a semi-automatic firearm. We have 4 baggies, green leafy substance. I think the officer has a reasonable suspicion based on his other observations as to what that might be. We have the burned joint or burned rolled item, and then we have this mysterious bag of pink pills. Well, I can tell you what would have happened in a real stop was upon finding those pills, the officer would go on to drugs.com and they would look up the pills and they would look what they look like, if they had any specific markings, and they would make a determination as to what they suspected those pills would be. After that, it is likely that what the officer would do was get out a presumptive testing kit. A presumptive testing kit is a kit that each officer is assigned, and they have a bunch of them, and they're certified by the state, and they indicate the presence or absence of certain chemicals. And depending on what that presumptive came back, you drop it in a baggie, it turns a specific color if that item is present. He holds it up next to a color wheel and then would write that in the charging affidavit upon decision to arrest. Oftentimes that is correct or sort of correct. Oftentimes the substance will come back with a little different chemical makeup. And what would happen to those items of contraband, the firearm would be secured and it would go off most likely to FDLE, the Florida Department of Law Enforcement, to make sure that it is a functioning firearm. A firearm is any object that is designed to or can be converted to expel a projectile by an explosive charge. So it has to actually be a working firearm to be considered a firearm. Does a starter gun count? Well, it expels gunpowder through the action of an explosion. It is considered a firearm. The frame or receiver of a weapon can be considered if it's proven to be in a functional firearm. So if the firearm was to go anywhere in the charging decision, it is likely that it would be tested. The marijuana, unlikely to be tested. The law is fairly clearly established that if it looks like marijuana, smells like marijuana, it's marijuana. It's getting a little bit more murky with the legalization and the marijuana cards and legalization of different forms of marijuana such as hemp. I'm not sure what hemp is used for if it has no THC, but it is a authorized substance, and because it smells very similar to burning cannabis, it is creating some confusion in the area of identification of marijuana. Now look at how this marijuana was packaged. There's 4 little individual baggies, and they were all in one baggie, and they all got pulled out one at a time. They're all in kind of equal amounts. Could that raise some suspicions in the charging decision that maybe this isn't just for Danny defendant's personal use, but maybe that he is supplementing his income over there at your favorite restaurant? I suspect so. I suspect that that could be a consideration, the way it's packaged. How about the issue of medical marijuana? We've all heard that things are changing as to the perception of medical marijuana and the prescription cards. Well, it's fairly established that if you get a prescription for medical marijuana, that has to be in the original container from which you obtain it, and it is supposed to be used in the confines of your protected area, which is your home. Once it's out in the car, in a baggie, it's unlikely to be covered even if you have a medical marijuana card. Drug paraphernalia, let's talk about that one. That is a first-degree misdemeanor. Do you see any drug paraphernalia here in this picture? Yes. Yes. Who said yes? Okay. What drug paraphernalia do you see? The baggie. Seems odd, right? Drug paraphernalia, a baggie, any object that can store a suspected controlled substance can be considered as drug paraphernalia. So, absolutely correct. This baggie, 99 times out of 100 will be charged as drug paraphernalia. The rolling papers, I don't know, he said it when he spread everything out. There's rolling papers and that rolled joint, the paper that contains the green leafy substance within, perhaps could be considered drug paraphernalia. So we've done the presumptive tests of those pink pills. They're not in a container that has his prescription name on it. They're in a baggie, again. And they're going to go off to FDLE, and FDLE is going to smash They're going to smash one of those things up. They're going to put it into a mass spectrometer. It's going to separate all of its component parts and all of its component molecules, and it's going to spit out at the end some kind of chemical formula. The chemist will verify that that chemical formula falls within the controlled substance statute, and then they will weigh the substance, hopefully without the container present. Sometimes they'll weigh it with the container, and then it becomes a exercise in math as to how much to subtract. And that's going to make a lot of difference in Danny's life when it comes on to the next thought, which is what is going to befall poor Danny once he gets to the jail. Well, Officer Johnny Law is going to write up his arrest affidavit, and he's going to say, I suspect that the pink pills contain fentanyl. And the law says they don't have to be solid fentanyl. Even the slightest bit of fentanyl in that giant pill can be weighed all as fentanyl. He'll be transported to the county jail. He will be eligible for consideration for bond or pretrial release unless he is charged with a dangerous crime or that he's charged with a first-degree felony that's punishable by life in prison. Then there are a couple of separate hearings that he would undergo before he would be considered for release. But I suspect that Danny defendant is going to be granted a bond on his charging affidavit, and if he is unable to post that bond, he's going to see the judge the next day at initial appearances, and the judge is going to make some decisions as to whether to stay that bond amount or reduce that bond amount. After that, if Danny decides to bond out of jail, he is going to wait for a charging decision by the state. Just because he's been arrested does not mean that his court case has now initiated. The Office of the State Attorney only can initiate a felony case by the filing of an indictment or an information. Indictments are reserved for capital cases and some sorts of corruption cases. Ordinarily, 99.9% of the crimes in our circuit are charged by information. So the charging attorney over at the state attorney's office, not necessarily the attorney that will be prosecuting the case, but a charging attorney would take all of the information from Johnny Law's arrest affidavit and make a filing decision. Johnny Law would receive in the mail, or if he was still in jail at the time of his time of his initial appearance, an arraignment date. At arraignment, he would be formally advised as to what the decision of the charging agency was, in this case, the state attorney's office, and he would be asked, hey, are you going to hire your own attorney, or would you like to be considered for appointment to one of our attorneys at the public defender's office? He'd fill out a financial document. The judge would make a determination based on the numbers on that financial document, whether he qualified as what is considered indigent for purposes of appointment of the Office of the Public Defender. After that, the fun begins, and that is where next week starts for you. Next week is pretrial motions and litigation, and then finally, the focus for Judge Wilson is the last stop in Danny defendant's saga, which would be the trial and sentencing. I want to briefly touch one more thing before we introduce you to your speaker for next week and take questions, and it is that firearm. Firearm was of significant concern to the law enforcement officer, I can imagine, and its proximity to contraband or suspected contraband also a concern. Is it illegal to carry a gun in a bag in your car? No. As of 2023, carrying of a concealed firearm used to be a third-degree felony, but is no longer a third-degree felony. Florida is not a concealed weapon state. In fact, it is an open carry state. So if you wish, you may wear your firearm like a cowboy on the side of your hip. Possession of a firearm by a convicted felon. Remember at the beginning of our discussions, we know that Danny is a convicted felon because he messed with the mascot statue of his rival college. The answer is yes. It is a very serious felony to possess a firearm when you are a convicted felon. However, That status is in flux right now. We have received an advisory opinion from the Attorney General's office that says that while possession of a firearm by a convicted felon of a dangerous crime should be regulated, we're not all that excited about the part where it's possession of a firearm by somebody convicted of a non-dangerous crime. In fact, we're so not excited about that if that is appealed, we're not going to have our attorneys argue against it. So we have gotten a clear directive that, hey, state attorneys, if you file possession of a firearm by a convicted felon and that felony is not a dangerous crime, and that's recognized by another statute, there's a list. If it's not recognized as a dangerous crime, if they get convicted and appeal it, we're not going to send our attorneys to defend that decision. So I think that's going to change. I think the legislature is going to formally change that in the next session. There's going to be lots of discussions, and they're going to be asking you, the community, for your thoughts on that. So definitely contact your legislator if you believe that that is not a responsible decision in your community. Finally, 775.087 is the enhancement statute. It is the baddie. It is the one, you've heard the 1020 life statute. Possess a firearm in the commission of a felony, 10-year minimum mandatory. Shoot a firearm in the commission of a felony, 25-year minimum. If you hit somebody, up to life. So that is a bad one, and it raises the level of trafficking. If this is a trafficking amount, let's say there's one speck of fentanyl in those pills, and it's not because they came from the pharmacy, because somebody mixed them up in some basement somewhere, and they, in order to increase their feel, included just the smallest bit of fentanyl, it is likely that that amount would be a trafficking level. Now, you think of trafficking as, you know, Pablo Escobar and bringing giant bags of cocaine across the border. No, it is simply a possession in an amount. For fentanyl, I believe that amount is as low as 4 grams. So the trafficking levels dramatically increase those levels. And as I said, when you get into those prescriptions, you can weigh the whole pill, and those add up pretty quick. If they determined that he actually possessed the firearm during the commission of this trafficking, he would be subject to a day-for-day minimum mandatory sentence of 10 years. So no good and gain time, 10 years. So Danny's got some things to litigate in his post-arrest case, and the Honorable Cherish Adams is going to be your presenter for next week. She is going to walk you through some of those potential issues and discuss what the positions of the relative attorneys would be. All right. So I have just a few minutes left. I am happy to answer any questions that you may have. Let me preface this. I'm going to give you my best try to be completely honest and as legally accurate as I can. Give legal advice, and my opinions are mine alone. They do not represent the Ninth Judicial Circuit, the legislature, or the Supreme Court. But with that admonition, I'm happy to answer any questions that you have. Yes, ma'am.
Would the officer, would he have been within the law if he examined the gun to see if it was loaded or unloaded, and would that matter in the case?
The question was, would the officer its bounds to examine whether the gun was loaded or unloaded, and would that have any impact on the case? The answer is yes. That would be done as a matter of course. They would immediately unload that firearm. Even though Danny defendant is in the back of the vehicle with the cuffs on, they're going to unload the magazine. They're going to put that in a separate baggie, and they're going to put the gun in its separate baggie. It's likely they'll put the magazine in its separate baggie, and then it will go off and be preserved for testing. So would it have any impact whether it was loaded or not? No. The gun does not have to be loaded to be considered a firearm. It simply needs to be able to or readily converted to have the ability to expel that projectile by an explosive charge. Yes, sir.
You touched on the officer before you was in the process of pulling the guy over, calling in the vehicle and the license to David or whatever.
Sure. So he's sending that to his dispatch, and they're going to be running that tag check and the vehicle owner check, and to take a check to see if the vehicle has been reported stolen. There are human beings on the other side of the microphone. Patrol car. So pulls him over. Also for officer safety. Hey, I'm getting out of the car. I'm getting out with the driver of this vehicle. Here's where I'm at. And if you don't hear somebody to check on me, so it that point is saying, hey, I'm stopping this car. It's got this tag. Check it out. I'm going to get out and I'm going to see what I can see. Yes, ma'am.
Questions. So you mentioned that smelling, the smell of marijuana is not a problem, but you said that they're not supposed, that the minute they take it from their home and it's in the car, then
Yeah.
so why is the smell okay?
Because they can't tell whether it's a legalized form of marijuana like
But
hemp.
why should it be in the car?
Well, if it was a legalized form of marijuana like hemp, which doesn't contain the requisite amount of
THC.
tetracannabinols to be considered an illegal substance, then you can carry it wherever you want. So the distinction is the substances smell, the burning substances smell so similar that unless you are with a highly trained drug dog, which sometimes have been upheld based on really exhaustive training to determine the difference, that a law enforcement officer's plain smell of something that smells like burning cannabis is not determinative of probable cause. Did that answer your question?
I get what you're saying, but if they're supposed to not take it out, use it in their home.
Right. So we're assuming
Wouldn't
that
smell in their car.
we're assuming that the item is marijuana. Is that what your presumption is? Medical marijuana, any kind of marijuana that would qualify as a controlled substance. Yeah, then that would be a reasonable. What the plain smell doctrine eliminates is a law enforcement officer being able to determine that this is the illegal form of marijuana or a legal form of marijuana to establish probable cause. So legal marijuana that was hemp-based and did not contain the requisite amounts to be a controlled substance, you could carry that into a movie theater, I suppose, and light up, but that would be an interesting decision. Right?
Okay. So my other question was, why bother to charge with paraphernalia?
Yes, ma'am?
With reentry and transition, and I often see multiple charges for one crime,
Yes.
and it feels weighty.
Now we're getting into charging discretion. And charging discretion is a state attorney should not bring charges that they do not have a belief that they could prove beyond and to the exclusion of every reasonable doubt. Similar charges are determined on the Blockberger test, which is there is a charge that is listed out in the statute that contains all of the other elements of another one, then you can't charge them both. But if the elements are distinct and separate, you can charge them both. So this falls purely to a discretion decision by the charging intake attorney. Yes, ma'am.
Thank you, Judge Carsten. I have a question. What if Danny was traveling with his people and he's being approached by the police? In the car, just get very upset with the police approaching. How should Danny behave?
Okay, so the question is if he has other people in the car. A pit bull. Okay, so if he has a dog in the car.
Not the singer, a dog.
Gotcha. Okay. All right. How should he react? Okay. I think it would be responsible of Danny to keep the windows of his vehicle closed, to communicate with the officer that I have a dog in here that may not be friendly. If you open any of the doors, I think it's best if I come out and talk to you outside of the vehicle, and the officer would be very, very happy if that conversation happened. If you have a conversation with that, it is a good idea to keep your hands on the steering wheel. The officer is going to be desperately trying to look through your tinted or slightly tinted window to see where your hands are. If they're nice up high, you're going to alleviate a lot of his concerns. If you are lawfully carrying, if you will simply tell the officer, by my right knee, I have a firearm, it is holstered, and I am waiting for your next instruction. That will be greatly appreciated by the officers. Communication, officers are most tense when they're coming up to that window. They're most tense. They don't know you. They don't know you're a good person. They don't know your dog loves everybody. They're worried about them getting hurt and going home to their families. So if you will communicate with them and do it slowly and calmly, and most importantly, let them see where your hands are, you're going to alleviate a lot of those concerns.
Keith.
So good question.
Keith, right here.
Hi, so sorry, I have a cold. Okay, but back to this about the Miranda warnings. Let's say like a defendant start making like statements before the officer can even Mirandize. Can they use those statements in court, like during trial?
Yes. Prosecutor loves spontaneous statements. Spontaneous statements. Remember that when is Fifth Amendment invoked? When they're responding to questions designed to elicit an incriminating response. If he'd have walked up and said, "Oh, you got me. I got a gun in the back, and I got drugs, and I just shoot me." All of those statements are coming in. All of them. So if he's not responding to the officer's questions or he's not in custody, those spontaneous statements are gold for the prosecution. So excellent question. All right, ladies and gentlemen, I believe that we have exhausted our time. I hope you found the video and the discussion to be informative and a little bit entertaining. If you did not, please remember, again, my name is Judge Bob Egan, and it's been my pleasure. And all of you, I think I'm going to fully invested in Danny Officer Law's saga. So thank you very much for your attention, and hopefully we'll see you next week.
One other thing real quick, and you need to get out of here, but this is what judges do every day, is skilled lawyers will literally break that footage down frame by frame. Was there probable cause for their stop? Was there articulable suspicion to continue the search? Does it matter if a spontaneous statement is made before or after handcuffs are put in place? All of these things are analyzed by very skilled lawyers, and they are brought before a judge in motions, which I think we're going to talk about next week, okay? So thank you all so very much. Drive safely. We don't want to see any of that on the way home. All right, thank you.